Hello and welcome to the live session of Narayana IAS Academy. I am Yogesh Kottavar and I will be discussing an important issue from Karnataka. Recently, the governor of Karnataka has given his approval for the prosecution of the sitting chief minister Mr. Siddaramaiah. So we are going to discuss the constitutional angle of it, whether constitution allows such approval to be given by governor even against the aid and advice of the council of ministers. Now for us it is important to study the powers of governor, and if you look at the syllabus in prelims also and in mains, this question can be asked because in mains GS paper 2 talks about appointments to various constitutional posts, its powers and functions, and governor is a constitutional position. Now before moving on to the article, look at this previous year question. It says, consider the following statements. Number 1, no criminal proceedings shall be instituted against the governor of a state in any court during his term of office. Second, the emoluments and allowances of the governor of a state shall not be diminished during his term of office. This shows that UPSC may ask some kind of factual questions from these topics. So you must be ready for this. Now moving ahead, what is the context? See, there is a corruption case related to land allotment. Here we are talking about the land acquisition. If you go to any state in India, the land acquisition is a very normal phenomena. See, for example, government wants to construct a building or a project, a metro project for example. And for that they need some land. So for example, here they are building the project and here there is a private land. The land is owned by a private person. In that case, what government will do, they will acquire the land for the project, but government will provide some kind of compensation to that private individual. Now this compensation will include two things. First, the compensation will have monetary amount, that means some amount of money will be provided to that person, and secondly, alternate land will also be provided to that person so that that person can be rehabilitated and resettled to that location. Now what has happened? Recently, one allegation was made, a complaint was made against the sitting chief minister Siddaramaiah that when this alternate land was being provided, some of the portion of that land is allotted to chief minister's wife, and this is completely against the policy measures. And here there is a corruption. That's what the allegation is. The case is still going on. We still do not have any evidences to prove this point, but we will wait for the evidences to come. Now right now what has happened is that the governor of Karnataka, he has given the approval for going ahead with that corruption case or the prosecution against the sitting chief minister. See, whenever you are going for a corruption case, you go for this Prevention of Corruption Act, and there is a section 17A. It says that if you want to go for any kind of complaint or allegation and move ahead with that case, here you need a prior approval. That approval should come from an appropriate authority. So for example, you are going ahead with a complaint against an IAS officer. So you need a prior approval from a higher authority, maybe the secretary of the department or some other person whom you can consider the rightful authority. Without that approval, you cannot move ahead with this case. Why? Because there are chances of fake allegations against any public official. So same is the case over here. So here when that private complainant wanted to go ahead with that complaint or case, he reached out to the governor of the state, and governor has given that particular approval. Now here, while giving the approval, governor did not take into consideration the aid and advice of the council of ministers. Now usually constitutionally it is said very clearly that if governor wants to act, it has to act with the aid and advice of the council of ministers. Governor should not do anything whimsically. But here governor has gone against the aid and advice of council of ministers. So here we have reached out to a constitutional question. Now there is a political angle to this issue, that the case has come into picture because of party politics. You see, in Karnataka right now, the state government is led by the Congress party, whereas on the central side, we have BJP in power. So there is party politics, and this political politics has converted into a legal and constitutional question over here. Now, let's look at the discretion of governor. What judiciary says about it? What are the judicial precedents? That means the earlier judgments of Supreme Court, if we look at it, we come to know that judicial precedent says governor can exercise his discretion in some cases. What do you mean by discretion? Discretion means governor can use his brain, his reasoning, and decide on his own without requiring any aid and advice as such. But he can do that only in which cases? Where the Council of Ministers' advice may be biased or incomplete. So here judiciary is saying that if you think that the advice given by Council of Ministers is biased, it is not at all right, or it is incomplete, in that case you can do whatever you want to, you can go for your discretionary power. Now this matter has reached to the courts, so we expect that court should play a key role because it's a corruption issue, and if you want the corruption investigation to move on in the rightful manner or in an impartial manner, the role of court becomes very important. Now look at the powers of governor. Now this is very important from exam perspective. So governor has some executive powers. First of all, governor is the head of your government at the state level, and here it has to act with the advice of Council of Ministers. Secondly, governor has some discretionary powers. Now this includes discretionary power to decide on reserving a bill for president's consideration. This does not require any advice as such. Governor will decide on his own. Second, recommending president's rule. If governor thinks that there is a need of president rule in the state, he can recommend that to the president, and he can take decisions without Council of Ministers only when Council of Ministers impartiality is questionable, and this is the present case when it comes to Karnataka. Then there are some legislative powers also. See, when you look at the Legislative Assembly of Karnataka, the head again is the governor. So governor can summon, prorogue or dissolve the state assembly. Even governor has to give the address to the state legislature periodically. Then governor has some judicial powers also. See, just like president, governor also has powers to pardon, reprieve, respite, remit a person's punishment. Then governor has power to sanction prosecution. We said that in case of corruption, you need prior approval of an authority. So governor is that authority when it comes to MLAs, when it comes to chief ministers, and when it comes to normal public servants. So here specifically, even if we talk about chief ministers, the role of governor becomes very, very important. I hope you like this video. After this, if you want any more updates on this, please like, share and subscribe to our channel, official channel of Narayana IAS Academy. Thank you so much.